Hello, everybody. I am Sophie Stalla-Bourdillon. I am Senior Privacy Counsel and Legal Engineer at IMUTA, Professor in IT Law and Data Governance, and Editor-in-Chief of the Computer Law and Security Review, which we call CLSR, which is sponsoring the panel, and which is a leading journal in the field of information technology law. So welcome to this panel, multi-party data sharing and data subject as beneficiaries, how to accelerate accountable data sharing. Just a quick note, we've had a few issues before joining the panel. We are hoping that we'll get another speaker on board, so please bear with us. We'll try to do our best to entertain you. Not only CLSR actually is sponsoring this panel, this year is also offering a venue for publication to speakers and researchers at CPDP. In addition to the opportunity to publish in the proceedings book. So share the news, and if you're interested, do get in touch. We've also got some illustrious members of our team mingling in the crowd, such as Alessandro, Henry, and Edina. So now to cover the topic of our panel, so data governance, and data subjects. Research in the field of data governance and recommendations for the creation of what the Open Data Institute calls data institutions is not necessarily COVID related, although these data institutions are obviously particularly relevant in types of crisis. Just by way of example, that Wendy Hall and Jerome Pesenti, who reported on how boost the artificial intelligence industry in the UK, recommended in 2017 to facilitate the sharing of data between organizations holding data and organizations looking to use the data. And to do that, the recommendation was to for government and industry to deliver a program to build data trust. In other words, proven and trusted frameworks and agreements to ensure exchanges and secure and mutually exchanges that are secure and mutually beneficial. From a UK perspective, I could mention a few very interesting initiatives. I'm not sure whether they will fall within the definition of data institutions. We will talk about that. The UK Data Service, the Welsh Sale Data Bank, Clinical Practice Research Data Link, and so on. Now, more recently, in the EU, we've got a new proposal for a Data Governance Act, which is meant to do three things: to facilitate the reuse of public data, to regulate data sharing services, and we will discuss to understand what this actually means, and to propose a framework for voluntary registration of entities that collect and process data made available for altruistic purposes. And we shall try to understand as well what's this notion of altruistic purposes actually mean. So it's a very interesting proposal, which is very topical and is coming also at a very interesting moment. As you know, advances in the field of data science, machine learning, AI have meant that data scientists have been eager to get access to data and more data and more data. And which is true, that was true prior COVID, and this is even more true with COVID. So the purpose of this panel is not so much to discuss whether access to more data could make the difference. We are going to assume, for the sake of the exercise, that there is a legitimate justification for sharing data between different parties, and therefore ask the questions how this should happen in practice, and whether there is a need to build data institutions to enable that sharing. In other words, we'll try to understand what is the added value of such data institutions, and how can we help empower individuals and facilitate the exercise of their rights while promoting data sharing between multiple parties. So to discuss this topic, CLSR has been gathering authors published in the journal, policy makers, and industry. We will start with Stefano Bertolo, who, after studying philosophy and cognitive science and 2 brief stints as a researcher and software engineer for the past few years, Stefano has worked as a scientific program manager for the European Commission in Luxembourg. After Stefano, we will follow up with Denise and then Alexsis and Elsley, and I'll present them each time before the intervention. So, Stefano, you are very well placed to describe what we've got in the proposal of the European Commission. Could you briefly explain the types of activities covered by the proposal for a regulation on European data governance, the Data Governance Act, so that we are all on the same page?
Right. So there are really 2 issues. The first Yeah, so do you have me now?
Yeah.
Okay, so I will start over. So there really are 2 issues to understand here. The first one is an issue of content, and the second one is an issue of the tool that was chosen to deliver this content. I will talk about the tool first. So European legislation exists in many forms. And the 2 most important ones are directives and regulations. So a directive is basically what a software engineer would call an abstract class. So it basically says, these are the principles that the union wants member states to follow, but each member state is now free to implement these principles in the legislation of their own country. And then there are regulations that are addressed to all subjects of the union at the same time. So a regulation does not, a regulation is a little bit more detailed and also more concrete, because it requires from the outset for everybody to work with the same rules, as opposed to delegating to member states legislation on the subject. So what we're discussing here is the Data Governance Act that is being delivered as a regulation. So it's the more specific type of legislation that binds those it addresses in the text of the legislation itself. Does not require a transposition in national law. So the content now. So as I discuss the content, it will become a little bit more clear why a regulation was chosen as the legislative tool as opposed to a directive. So the idea is that, which has been recognized already from the previous Commission, but is very prominent in the political agenda of the present European Commission, is that data assets are inputs and outputs of economic activities, not to mention valuable for various types of societal goals. So the purpose of the data governance regulation is to introduce enough legal certainty to make people feel confident in engaging in economic or other type of activities that have to do with data sharing. The subtext of Sophie's question, as I understand it, is, well, what type of data does it touch on? And the answer is the Data Governance Act is completely horizontal. So it addresses any type of data that is collected by party A and can be reused by party B for reasons that have been agreed between the 2 parties from the outset, and that's one type of interaction, or for reasons that were possibly completely unforeseen when party A collected the data asset. Now, to make things even more complicated, there are certain specific verticals, for example, transportation and car manufacturing, where legislation already exists to regulate how parties could or should interact with one another in the exchange of data. And so the regulation here is being proposed with no prejudice to that pre-existing legislation. There was one more point I wanted to make. Yes, it's not just a matter of doing census of where data assets exist that today are not being used for economic or social activities in Europe, but it's also a bet, if you like, in terms of, I guess you could call it industrial policy, to create, to connect to Sophie's original question, the type of institutions that would allow European data sharing actors to prosper in a way that is somehow alternative to the large multinational platforms that we are all used to, that have been collecting data for the bettering of their own services with great success, as everybody can see, over the past decade or so. It's basically, it's a legislative instrument that is designed to build the legal certainty that is expected to be necessary for a new generation of European data sharing actors to come onto the market.
Thank you for the introduction to the proposal. To try to better understand the scope of that proposal, there seems to be a distinction that is being drawn between data sharing services and data brokering services. Right. Could you say a bit more about that distinction?
Yes. Okay, so a data broker is an entity that takes data assets from whatever sources and manipulates them to create some value added. And so the crucial bit there is that the data broker, so as you hand over your data asset to a data broker, typically under some form of compensation, you have no real control on what happens downstream. So the data broker has made an agreement with you, data assets have changed hands, and from that point onward, the data broker can do whatever they want with the data and build whatever services that they can sell to whichever customer they decide. So that's what a data broker is under this legislation. A data sharing service is an economic operator whose only purpose is to make sure that the demand and offer for data assets can find each other. And so it has the ability to set up a platform where owners of data assets can advertise the availability of the data assets. It can operate a platform where organizations who need data assets can specify what data assets they need. It can be a trading platform where the two parties can meet and establish at what price and conditions they want the data assets to be shared. But none of this allows the operator of the data sharing platform to do anything else with the data that comes through the platform, and in particular, not to sell any services. And so the regulation establishes the legal notion of a data sharing service, and it establishes two requirements, and these are both designed to create confidence in data sharing exchange activities. So the first requirement is that anyone who carries out the type of economic operations that I just described is required to notify their national authorities that they are operating such a business. And the national authority, from that point onward, has the right to inspect that they are doing so under certain principles established in the regulation. And it also says that if you are running that type of economic activity, you are not allowed to do the other type of things that data brokers do. And the reason for this is to allay the fears of those organizations who might have wanted to participate in a data sharing market, but decided not to, because of the risk that the assets that they contribute would become of possibly competitive business intelligence on the part of the data broker, who would at this point be allowed to inspect and analyze the data. So if you like, it's a little bit similar in concept to the segregation that you have between those who own the fiber and those who operate a telephone service. So the mechanism is established in such a way that you cannot squeeze out your competitors in the market of telecommunications because you own the network. So, and a similar concept happens here. So if you are in the business of setting up a data sharing platform, you cannot also sell services that are based on whatever insights you gather based on the data assets on the platform.
Okay. So if I wanted to translate into potentially another terminology, maybe a data sharing service is a data marketplace.
Yes,
that be covered therefore by
yes, but
yes.
it's crucial that that's all it can be. So it is established exclusively for the purpose of data asset holders and data asset seekers to meet one another and trade if they want, but not for any additional type of intelligence.
And so the underlying assumption is that their brokering service is potentially riskier to some extent.
The assumption is that there are today organizations who may be uncomfortable putting their data in the hands of a data broker that would feel, on the contrary, completely fine doing so in the data sharing environment that I just described.
Okay, and so I think you've already touched it a bit on the answer to that question, but why adopting a regulation to govern data sharing services?
Right. Okay. So this goes back to the fundamental philosophy of the European Union. So one of the greatest accomplishments of the Europe, I know that talking to people on the other side of the channel at this point is delicate, but one of the great accomplishments of the European Union is that we are a common market. And so that makes it easier for you as a producer of a good or a service in Portugal to sell it to someone in Finland. So that's why the common market exists. So the purpose of having a regulation is to create a European common market for data. So again, if you are a data asset creator in Poland, it should be possible for you to trade with somebody who needs your data in Spain, because there is a set of standards that you both use to describe your data, a set of practices that you all abide to when a data contract is being established, that makes the operation European-wide. And so not only that, but again, there is an issue of timing. So because the data economy is something that will happen, whether or not anyone legislates about it, the European Commission made the calculated analysis that it would be possible that if the Union did not legislate, you would have member state A and member state B and member state C all legislating, but all in a different way. And so at that point, even if in those three member states there is a legislation that has the same principles as the Commission seeks, maybe the technical details will make it harder for entities established in each of these three countries to trade with one another. And so the idea was, okay, so since this is going to happen anyway, let's step in, let's use a regulation as a legislative tool and make it easy from the get-go from anyone who wants to enter in this business to enter it knowing that the principles that they follow are exactly what everybody else around Europe will be following.
Okay. Okay, and just one last clarification. Obviously, the EU is already famous for its data protection framework, which is seen as being one of the highest common denominator across the several jurisdictions, which are the member states. With this proposal, the European Commission wants to regulate the use of both personal and non-personal data, and is trying to import some concept that we were finding in the data protection framework to try to regulate non-personal data. So,
right. Okay. So
briefly, why regulating both?
right. Okay. So maybe I'll turn around your question in a different way to make you see the principle that underlies both. So first of all, the General Data Protection Regulation, which is again also a regulation, obviously continues to apply. So and one of the interesting technical points of the General Data Protection Regulation is that it makes provisions for anonymized data sets. So an individual rights are protected up to the point where various types of anonymization techniques can be brought to bear on a data asset to the point where it would be prohibitively expensive to try to re-identify the individuals in question. So if a data manager can prove that they have established due diligence in so anonymizing their data assets, they are then allowed to carry out on them the type of analysis that would not be legally allowed if the identity of the underlying data subjects were recoverable. The Data Governance Act is doing more or less the same thing with respect to certain type of data assets that are in possession of public bodies that generate typically from the public sector. A very simple example might be price monitoring. So there are statistical offices established in all European countries that maintain, for example, indicators about inflation. And how do they do? How do they do that? Not, and maybe not all of them, but many of them monitor the change in prices by examining large data assets that they receive from large supermarket chains. And there is a frame agreement between commercial operator and statistical offices that say that, yes, I, supermarket, make this data asset available to you, statistical office, so that you can reliably compute an inflation index, but that's all you can do with it. And there's nothing else that you can do with this. And in particular, I'm not legally liable if you see anything that you don't like in the data set that I'm offering. So the Data Governance Act is basically say, okay, but so just like in the GDPR, we make it possible to carry out various forms of analysis if the data asset has been anonymized. Public bodies could and should do the same with these other type of assets. So again, a topical case was when in March 2020, we had the first surge of the COVID epidemics. A number of European telecommunication operators shared their an anonymized version of data assets from their networks to help national authorities understand better how people were moving and how that could have an effect on the spread of epidemics. So that's a very clear-cut example of a data asset that is initially collected by a private operator that suddenly becomes of extreme importance for societal reasons. So the Data Governance Act establishes the conditions under which a public body would, and in fact, in certain cases, should be allowed to share such data assets by applying various forms of anonymizations, just as foreseen in the General Data Protection Regulation.
Okay, thank you for the clarification, Stefano. Let's turn to Denise. Denise is a CLSR author. She's an affiliate researcher at Leader Lab, Diapolis Institute, Scuola Superiore Sant'Anna in Italy, where she serves as a DPO, and she's also lots of experience in research because she's involved in many Horizon 2020 research projects. So let's go back to GDPR for a minute and try to understand to what extent this framework already could be used as a way to accelerate access to data for research purposes. Do you see any specific hurdle that researchers will need to overcome in order to access data that falls under that framework?
Hi, Sophie. Can you hear me? Are you hear me?
Okay, we can do that. So it seems that Denise can't hear us properly. So we'll move to the next speaker, Alexsis. Alexsis, hopefully you can hear me. Alexsis,
I can.
Okay. Alexsis is the founder of Lapin. She's pioneering new data governance frameworks to try to accelerate technology adoption and social good. And she leads the Jersey Data Foundation project. So Alexsis has been working on the Data Foundation model, which is a kind of data institution. Can you explain us what the Data Foundation model is and its inspiration?
Yeah, definitely. Can you hear me,
Yes,
Sophie?
yes,
Okay.
yes.
Loud and clear. Okay, great. Yes. I think we kind of, when we really question would happen if we could share our data safely. Would we be able to make better informed decisions, flourish as human beings and communities, and why, there's an opportunity to build smarter, cure incurable diseases if that was possible. So the inspiration for the Data Foundation came from that area. We could see that the power of data was there, and it's introduced at an exponential rate. We know that we create 1.6 data per second for every person on Earth, lies 0.5% of it, and we share even less. The question asked was, if people aren't sharing data, we encourage them to do so. And an example that's already been talked about just in the speaker before, about the benefit of data sharing at scale. So really, we started a great example, because when the new coronavirus was first identified in China, it took scientists only a few days to sequence its genome. And by last year, the results were published worldwide for news. And this data proved to be essential, as it contained vital clues about how the virus evolves and spreads and treated. And the speedy publication managed to bring forward things like vaccine testing. But this was a really rapid global action for a health-related problem, and really that's so unusual, and it required advanced collaboration and cooperation between the private sector and government, as well as the regulators internationally. So if we believe that data's knowledge and that knowledge should be shared, it also comes with another side of things. It also comes with increased responsibility, because as you increase data sharing, you increase the likelihood of misuse and harm, and particularly when it comes to personally identifiable information being in the data. You could see that privacy protection was in constant tension with data access, and therefore the balance of risk to examine. So the question then became, well, if we be shared, then how do we do this responsibly?
So how can we incentivize responsible data sharing with this model? Quickly.
Well, we know that, I mean, we've seen a lot of attempts to find legal, ethical, and repeatable mechanisms or structures to support data sharing, but they really haven't quite succeeded. But they are emerging through the data institutions movement. The designs of these was really, and still is, in hot debate, but we can see that there's some really common good practices emerging that do encourage more sharing, such as independent stewardship of data, oversight of how the data processing takes place. There's an advocacy for transparent decisions to take place in the open and equal representation of all stakeholders involved in the sharing. I would say that any model creates the opportunity for collective decision making, which also includes for the voice of the individual, of the person, to be heard, trust, and that will incentivize sharing. To talk a little bit about how data foundations do that, or whether we have probably run out of time, I don't know.
And so if this is and if this could incentivize data sharing, why is it that we are not seeing that many prototypes popping up around? Why is it that jurisdiction with exploitation law are not trying to build these things?
Because the model we've been working on, we have a really unique legislation. It's a perfect fit for data foundation to be built, and it builds in a lot of these really fantastic design principles that are really important in data governance. But I think that there's three main jurisdictions with legislation haven't yet invested, which I can touch on quickly. The first is really the chicken and egg scenario, which happens in every model where a new market and the things like the data economy coming into place. The of 6 prototype with the model, there's little incentive for private sector investment. It's possible, of course, for governments using their own data and others. It's very important that data sources, in order to prove it can. But then there's a challenge around the availability of entrepreneurial skills within government, and also sources of funding being available, particularly during. I think the second reason is that typically commercial data sharing occurs between products, and the use of a novel structure in which to where data providers contribute collectively to the decision making is very new. And whilst we know that these types of models, and particularly a data foundation, solve many of the challenging problems which limit data sharing today, they are new and unproven. And it just takes time for organizations to look at these to solve their data sharing problems. Probably on a more positive note, though, there are many countries that have got task force and action groups in this area, and they're doing some really progressive and impressive work. And we certainly believe that these structures will become much more common in countries wishing to dominate in the development of artificial intelligence. I think the third reason is that it is around the use of the data foundation itself, that private arrangements are just that, they're private. So there's little independent oversight, and if they're not processing personal data, then data protection regulated. So invoking a data foundation, which is in the way the charter of the foundation is declared, and candidness over the, as well as the adoption of the code of conduct, this all creates accountability very publicly, and that can actually create fear in itself. So As privacy and data protection laws are made more comprehensive and enforcement arsenals are strengthened, it becomes harder to convince the compliance person to test solutions and arrangements that don't distinct categories. And I think that's why there is a limitation in actually bringing these models from theory into
practice. Thank you, Alexsis. So it's hard to incentivize, I suppose, accountability and transparency, even through regulation, be it at the regional level or even at the national level. Denise, can you hear me?
Now, yes. Apologize for earlier.
Okay, that's working. Fantastic. Let's assume for a second that we are under GDPR and we've got only GDPR to look at. Assuming a GDPR is applicable, is it possible to accelerate access to data for research purposes under that framework?
Yes, I think firstly, thank you for the invitation to this panel. Yes, I would like to give you some experience, bottom-up approach that I gained by my experience as data protection officer in 2 universities. In the research field, we know that the GDPR created with Article 89 and Article 5 a regime of favor for data sharing for research purposes. And but as Stefano told before, Article 89 is one of those disposition of the regulation that gives the opportunity to the member states to introduce national safeguards and national implementation. So we have a first barriers, regulatory barriers to share data within different states members due to the possible national implementation that can give different safeguards that can be technical ones and also organizational ones. So perhaps from a bottom-up approach, the main way to really reach the opportunity of sharing data and achieve the challenge of sharing data as making data as open as possible and as close as necessary is to start to think about the data management plan as an approach to develop future strategies in building up a research infrastructure to share data or to build up this marketplace that Stefano was referring to earlier. So what is the data management plan? Data management plan is a document that we are supposed to organize in order to illustrate and plan how each kind of data has to be collected, stored, and processed. And so the data flow that includes both personal and non-personal data shall be analyzed with the technical as well the legal constraints and barriers and safeguards in order to be compliant with the applicable legal framework. So from this perspective, if we recall the FAIR principles, that our data shall be findable, accessible, interoperable in order to be reusable, and this is the basis of sharing data and of sharing data between multi-parties. Perhaps the data protection approach that has been introduced with the GDPR, thanks to the principle of accountability and data protection by design, becomes in a wider perspective, the enabler to an accountable approach toward data management. So from this perspective, in each data flow that may include personal data, we have to refer on GDPR and also national implementation in order to analyze whether or not for a given purpose data can be shared or not. And in addition, for non-personal data, now we have to look at other regulation. We will see at the Data Governance Act once it will be enacted, but now we have to check on non-personal data flows or on open data directive PSI that updated the PSI directive. And so the legal constraints are related to, yes, personal data, but also when we try to share or we want to work and process a data set that we consider pseudonymized or even anonymized, if we cross this information with perhaps other data sets, the technologies that are able to process this data might become a new data set with information that decrease the level of anonymization, and so perhaps some safeguards could become applicable. So thanks to in this way, if we look at an approach that tries to standardize or create policy to simplify the work of those who are going to share data for different purposes, and in my case for research purposes, it's very, very, very difficult. So the main suggestion is to analyze each data flow at the very beginning, considering a data management plan, and analyze from a technical and organization and of course legal perspective how to be compliant. So in this way,
okay.
Sorry.
No, okay, no, I was just trying to visualize what you were saying. So if we follow the right process, you are saying it's a process-based approach. If you try to fill in that data management plan, then we are in a very good place to be able to claim compliance and therefore justify access to the data, and the GDPR is not acting as a barrier to that sharing. It's just requiring the implementation of a specific process that needs to be taken seriously into account. Just to be a bit more practical, are you aware of any specific initiative which would be trying to, again, accelerate access to data for researchers, try to scale in some ways compliance and make sure that it's not taking too much for researchers to follow that process?
Okay, yes, I can give you two examples, a theoretical one, a practical one. Practical one, a research infrastructure that aims at sharing social mining and data mining data sets for open science. So, and in that case, we decided to proceed with an internal audit in order to assess all the compliance grounds from an organizational viewpoint in terms of legal compliance for GDPR compliance, IPR compliance, trade secrets. Do you have the right to license, contracts? In that circumstances, we analyze all the data sharing agreements that were produced by researchers in terms of open data and open science. On the other side, more theoretical experience, we collected the national implementation on IP and data protection and copyright of several EU countries in order to to deliver blueprints for best practice and policies for data process, personal and non-personal data processing for research purposes. So in the first cases, we analyze case by case in order to solve problems and issues by using contract law and private autonomy. Let's do in this case how be compliant with all this kind of legislation. On the other side, we made the researchers' works, and we try to collect best practice and regulation and to find out a common core or a better law approach, and to give policy and guidelines in order to try to standardize and to facilitate researcher in dealing with these issues, but also dealing with these issues and to make researchers aware about legal constraints and technical constraints and different safeguards that can be applied in different countries is already the first step that can be useful to approach open data and can be used as an enabler and not only as a barrier to open science.
Okay. Very quickly, because I see some questions already popping up in the chat, and they are all very curious about what you think about the proposed Data Governance Act, and maybe if you can say a few words about data altruism. Could that be useful to actually facilitate compliance with Gdpr? If you think about that example.
Okay. Well, the idea is that the Data Governance Act shall be read together with all the European data strategy. So there will need an analysis and the huge work from researchers' sides to try to align the different notions and the possible overlapping between all the regulation that insist on non-personal data. Because as far as personal data is concerned, the GDPR is the Bible, because every other legislation is referring to GDPR in order to say here it is applicable and it is a pre-requirement, or otherwise here it is not. It is everything else than the personal data and the GDPR application. So under these conditions, the Data Governance Act could help open data and to share a new culture of trust and awareness on the opportunities to make data as open as possible, but considering that they shall be as close as required, and the requirement to be close as close as necessary is referred to the compliance to all the possible legislative framework. So if we process health data, we can not only deal with GDPR compliance, we have to deal also with the health legislation, sectoral legislation in each country, and perhaps within the country we have regional legislation for health data. So it's a multi-level issue that shall be dealt with also once that the Data Governance Act will be introduced and enforced.
Okay.
Thank you so much.
Denise. Let's turn now to Else. Who is an expert on data privacy regulations and privacy and fundamental rights, and she monitors the global privacy regulation landscape at Data Wallet, and she has lots of experience in the field of data governance. we've been speaking about regulations of all sorts, GDPR obviously, and the proposal for Data Governance Act. But even without this regulatory incentive to promote data sharing, things are already happening. And so from your perspective, what should a best practice data governance structure, which would support multi-party data sharing, look like?
Okay, yeah. So I think that's a very big question, actually a very complex question that somebody could spend 5 years on to write like a PhD thesis. So I'm going to try to keep it short by looking at just a few angles. So I think you can look at it from a technical angle, an organizational angle, a legal compliance angle, and also an ethical angle. So just to start off with the organizational part, I think it's really important for both the sending and the receiving company to have competent data governance teams in place. This tends to be underestimated because you even come across very large enterprises who are handling lots and lots and lots of data, but they don't have specialized people who are really focusing on how data flows through the organization. And I think that's a very bad start. And I think it's also very important for these companies to have a data strategy in place or a data charter, which can serve as a foundation for any data policies. So when it then comes to a data transfer, that they have a strong foundation and a specialized team to fall back on. And then from the legal and the compliance side, I think we've already mentioned it a lot, the GDPR. So if you are transferring the data of EU citizens, you are processing data because the transferal is processing. So you have to adhere to these 7 principles of the GDPR. I'm not going to go through all of them right now. But of course, the transfer has to be lawful, which means that it has to rely on one of the 6 legal grounds, consent being the famous one. It has to be fair. It also has to be transparent, which means that the data subject has to know that his data is about to be shared, also with whom, which data specifically, and for which purposes. And then speaking of purposes, there's also purpose limitation, which has been mentioned quite a bit already, which means that the transfer may not happen for any other purposes that were specified to the data subject. So that's only the tip of the iceberg, but that already kind of makes it clear that you really need a specialized team in place to sit down and to think all of that. Each individual data transfer, are these 7 principles being adhered to, and to also document that process. Then to move on to the next, the technical angle, there again, both the sending and the receiving company need to think about which privacy enhancing techniques they want to use. And unfortunately, you can't just give a one-size-fits-all kind of answer. They really have to look on a case-to-case basis. So for each individual transfer, what is the best technique to be used in this case? So they have to also understand, what are we going to do with the data? So what's the purpose for the data share, and what is the receiving party going to do with it? And based on those questions and answers, they can decide which technique to apply. So anonymization, pseudonymization, which of course are not to be mixed up, and often unfortunately are mixed up. So yeah, that's from a technical standpoint. And then the last but not least, I think, is the ethical component. Because even though in some cases, like we talked about the COVID pandemic, where it seems like the only ethical thing to do is to share the data, but you do open up a whole new can of worms in terms of risks. As mentioned already, when you're sharing data from party A to B, from B to C, from C to D, and so on, and the chain gets longer, this gap between the point of consent of the data subject and the actual use of the data becomes very wide. So it's very hard to make sure that the controls that were put in place all the way over here are still effective over here. And of course, one more thing I just want to mention quite quickly, data is not a neutral fact. It's often seen as this neutral thing, but of course data is interpreted. And the more parties you have, the more layers of interpretation you have, the more bias kind of slips in. So I think, again, it comes down to having a specialized team in place and really taking the time to think about these ethical risks to try to mitigate them. So yes, predicted a long answer, but I hope I covered the most important stuff.
You did. And so when you engage with your customers, I mean, do you often see these very specialized teams in place?
Unfortunately not. Like often it is very much underestimated. Also science is underestimated. As said, not even, you would say only the SMEs, the small companies, but even large enterprises underestimated what it means. You see often that they have people in double roles, which can work up to a certain point, but when you're really handling large data sets, analyzing data sets, and especially transferring data, and also purchasing data from data vendors, for which you would need to perform due diligence, etc., it is really much better to have specialized people who are just focused on that one aspect.
Right. And so, of course, you focus on data subject rights. When it comes to multi-party data sharing, obviously the data moves and end up being in different hands. How can we make sure that the data subjects are still in a position to exercise their rights?
Yeah, so that's a tough one. I think, to put it very simply and short, I think it's really important that consumers are put in real effective control of their data, which sounds easy but isn't. And I think it can be achieved through two key elements, the first one being transparency, and the second one, accountability. And to start with transparency, as said already, the data subject has to be notified of the fact that his data is going to be shared and what the purpose is of that. But they also have to be given a reasonable time frame to opt out. And in terms of transparency, what I've seen a lot, I think what we've all seen as consumers, is that you're getting 60 pages of dense legal text thrown in front of you and expected to read through this and accept or not accept. And of course, that is not transparency. At Data Wallet, you've just asked me like what I see in companies. We do see a positive trend in this perspective. We do see more and more companies who are really trying to talk openly and honestly and transparently with their consumers by providing human normal language and even visual privacy notices, which I think is quite good. And then the second aspect is accountability. Again, comes down to having also specialized people. It's important that both the sending and the receiving party really document how they have thought through their data sharing processes and also how they've done this with the interest of their consumer in mind. So if you have all of that in place, I think that data subjects can have robust tools to exercise their rights.
Okay, even if the data move around.
Even if the data moves around. So if the data moves around, I think if you come to the point that you're way at the end of the chain and you realize that the data subject has not given consent to this specific share, then that party should potentially update their privacy notice and try to contact these consumers.
Okay, thank you. One last question, which would, in a way, indirectly answer the questions related to actually their altruism. Obviously, the EU is being compared with other jurisdictions, and some have heavily criticized the Gdpr for not promoting, in effect, the free flow of information or not promoting data sharing in the way it should be. You've been working with the COVID Alliance in the US, because you're looking at both the EU and the US, which could be described as a data institution or baby data institution in some ways. Can you say a few words about your involvement with the COVID Alliance and how the challenges, if any, that you've faced in that context?
Sure, I think it's a really interesting topic to talk about in the light of this conference. So I headed up the ethics team of the COVID Alliance. And what the Alliance does is combine multiple data sets from different sources and to put all that together and then build a nice visualization layer for a specific user. So one prime example is the fact that they built a dashboard tool for governments, so for policymakers, where they could view the COVID situation in their county and make decisions based on that. So for instance, we combined mobile location data, which was already mentioned as a pretty sensitive type of data, also data about infection rates, how many hospital beds are available, etc. So you asked me about challenges. The first challenge that I could talk about is guaranteeing the accuracy and also the equity of the data that we sourced. we spent a lot of time building a very strong due diligence process to check our data vendors, because the whole tool relied on how good the data is. And this is more complicated than you might think, because it's very important to really understand what you are building on top of. So for instance, what we did was investigate, when we got a data set, for instance, we got like a bunch of mobile data, we really investigated which percentage of the population was actually covered in the data set, and whether any specific groups might have been left out, like for instance, homeless people or anything like that. And then what do you actually do with those results is the next step. So we would try to be very transparent within the tool about maybe potential biases or gaps that we would have in the data. So if we were to display in the tool, like people are moving from A to B, we would maybe also say, but actually we only have 60% of the population covered here.
Okay. So the COVID Alliances can be described as a data institution that is meant to facilitate and accelerate access to data for researchers.
Yes.
Just to give more details about.
Exactly, that's one of them.
Yes.
So they have the multiple tools. They have one for the governments that they can make decisions, and they also have this research tools, which basically use the same data, but then gives researchers access to it.
And so could we have something like this in the EU?
So yes, because of course the COVID Alliance, we had to take GDPR into consideration, because there is a good chance that we have data of EU citizens who are moving about, right? So we already took GDPR into consideration. However, in the EU we might get a little bit stricter, because we have all of these other guidelines as well, like the Data Governance Act coming up. But another challenge, for instance, that I can talk about is this problem of anonymization, this problem of potential re-identifying consumers. So that's a very GDPR kind of problem, because it's a GDPR that takes anonymized data out of scope, which is, of course, we only wanted to show anonymized data. But at some point, our product team, for instance, wanted to allow policymakers to draw a little shape, a little polygon around a group of citizens to see how they move around, which is a huge risk, because if you draw the polygon small enough, you might be able to re-identify somebody. So those are the kind of problems that we were faced with, which are typical EU GDPR kind of problems. Okay,
but you're optimistic, which is good to hear. Thank you, Elke. Looking at the question that I have, I wanted to go back to Stefano and try to cover actually the first question, which relates to, I mean, are we ready to reuse public data? So we have the expertise to do that, which, I mean, I can speak for the UK, obviously, which is not EU, but where universities have been actually used to try to build secure data centers and share the expertise for de-identifying the data. What's the state of play in the EU, and do we can we leak data? What about interoperability?
Right. So I will start from the last one. You can think of this as having a cascading effect, where the parties that most directly benefit from a certain type of standardization start exchanging data between themselves in that format, and everybody else who has an opportunity for reuse that at an earlier time was not being seized because there was an effort of converting data from one format to another that would make the enterprise unprofitable, now start doing so. So this sounds very abstract, so let me give you a very simple example of what I mean by this. There are many European countries, Italy happens to be one of them, in which when public authorities put out a call for tender for a good or a service, they require for submissions to follow a certain format. And when the contract is awarded, all invoicing should also be sent in digital format according to a pre-specified format. Now, once suppliers of goods or services to a public administration learn to use those formats for the purpose of servicing the contracts that they have with public administrations, they also put their house in order, if you like. And so they make life easier for their own accountants to start looking at how what is being produced and on what schedule, sold when, to whom, where, and at what price. So the point of establishing national authorities to assist public bodies with best practices for making the data sets that they already hold accessible for other purposes has the same character to it. So essentially, let those who most immediately can see a reuse for the data assets that they have in mind go ahead, and in the process propose standards that everybody else would benefit, because at this point there is, if you like, a standardized way of doing a certain type of things data-wise. And so I also would like to, in terms of standards, not just data standards, but it's also legal standards. So the Data Governance Act, in its fourth chapter, the one about data altruism, establishes the requirement for a European-wide consent form. So
Yes.
now, instead of having Finland, Portugal, and Spain all have to guess, okay, what exactly do we need to ask of a data subject to make sure that she is giving an informed consent to the reuse of her data for altruistic purposes, there is no guesswork. There is going to be, if the proposal is adopted by Council and Parliament, there is going to be a single European form where all European citizens will give their consent to their data being used for altruistic purposes in exactly the same format. And that's what should make it possible for data assets collected for these altruistic purposes, again, collected in Malta, to be reused in Austria.
Okay, and I think we are towards the end very quickly. So if I ask you a very naive question, is this understanding of consent that we've got in the Act consistent with the definition of consent in GDPR?
It couldn't possibly otherwise.
Okay. Thank you. Thank
Who
you
do you
so
think
much
we
all.
are?
Well, you never know. That was a very naive question.
Yeah.
Of course. So I'm getting a message saying that we are towards the end and we should be closing. Thank you so much, panelists, for being with me today and answering these questions and taking the time to cover this very complex topic. And thank you for the audience for all these very interesting questions. And hopefully we've managed to entertain you a little bit during an hour. Thank you so much.
Thank you.
Thank you.
Thank you.
Bye-bye.
Bye.